This is Colin O'Keefe of LXBN, and today I'm joined by Steve Augustino, a partner at Kelly Dry and author on the Telecom Law Monitor. We will be discussing the FCC's Open Internet Network Neutrality regulations that go into effect next month on November 20th. Steve, starting off with the basics, what are the most impactful measures in these open Internet rules?
Well, these rules are a new set of rules. They were very controversial. It's the first foray by the FCC into regulating internet service providers and what they may or may not do.
Mm-hmm.
The new requirements apply to all broadband internet access providers who offer service to the mass market, which is generally consumers and small businesses. In addition to that, what the content of the regulations is three new requirements for those providers. Number one, they're prohibited from blocking lawful content on the internet. Number two, wireline providers are prohibited from acting in a discriminatory manner, discriminating against certain types of traffic. That provision doesn't apply to wireless providers at this point. But the third requirement also applies to everybody, which is a new transparency rule. It's a new requirement that you disclose what your network practices are and the content of those.
I see. As you wrote about in your blog in August, many of the comments that came into the Office of Management and Budget after the rules were proposed, they kind of centered around the transparency rule requiring the disclosure of network management practices. Walk us through the crux of those complaints, and how do you think those will be dealt with going forward?
Yeah, I think that's the key issue at this point, is the transparency rule and what does it really mean. There's been a long path between the FCC's adoption of the rules and their effectiveness coming up on November 20th, and a lot of that surrounded what the transparency rules required. The crux of the complaints or the questions that were raised with the OMB review was the burden of the rules themselves. They argued that it was overly burdensome because the scope of the disclosures were very broad and the exact content was unknown, and therefore it was vague requirements that would impose additional burdens on the providers. Mm-hmm. So what happened with that is that OMB allowed the rules to go into effect, and what that really means is that on November 20th, all providers have to make a disclosure. And they have to make a disclosure of what their network practices are, what their practices are with respect to congestion. They also have to disclose speeds and the way they perform. We don't really know how detailed that's going to be. I expect that that's going to vary from provider to provider as to what they interpret the rules requiring. And so it's really going to be a period of probably a few months of kind of case-by-case examination before everybody reaches a general balance as to what is expected within those disclosures.
Mm-hmm, mm-hmm. That makes sense. And lastly, there's been much demand from consumers as far as net neutrality goes. They don't want to see their internet service kind of start to look like what they have with their cable subscription, with varied levels of access to content. There's been a lot of concern out there, just, on the web from consumers about that. Are these rules something that consumers can be grateful for? Does this really address those concerns? Is it related to those at all?
Yeah. Well, whether consumers should be grateful or not is a subject of great debate. I won't weigh in on that part of it. I will say, though, that to the extent the concern is over tiered service or having, you got to buy this plus this in order to make everything work, kind of like your cable TV or some cable TV subscriptions are. Unfortunately, I got bad news for those folks because these rules don't address that. They don't prohibit tiered service. A provider can engage in tiered service or monitoring or slowing down of service as you hit certain caps, things like that. Those are permitted, but it comes back to the disclosure part. They need to be fully disclosed. So the idea is that consumers would be able to choose with full knowledge as to which service meets their needs.
I see. That makes sense. All right, once again, thanks, Steve, for joining us. Once again, Steve Augustino of the Telecom Law Monitor. For more on these net neutrality rules, be sure to check out telecomlawmonitor.com and also lxbn.lexblog.com. Thanks, Steve.
All right, Colin, thanks very much.